Hi, Matt McCune here. Okay, let's talk about Chapter 7 bankruptcy. First and foremost, do not take this to be complete legal advice for your situation. Chapter 7 should be the starting point for anyone considering seeking debt relief through our bankruptcy system. Chapter 7 is the quickest and easiest way to get in and out of your debt through our bankruptcy process. You always want to look at Chapter 7 first. The goal of any bankruptcy filing is to get what's called a discharge. A discharge is simply a piece of paper signed by a federal bankruptcy judge that says you no longer owe certain debts. That's the relief you're seeking through the bankruptcy process. Well, the discharge in Chapter 7 comes 4 to 5 months from the point that you file, assuming everything goes relatively smooth. Compare that with your other option, that's Chapter 13. In Chapter 13, you make a partial repayment to your creditors, and that takes 3 to 5 years. So, pretty obvious that if the goal is to get your discharge and move on with your life, you should always look at Chapter 7 first. So let's talk about eligibility for Chapter 7. First of all, you can only file a Chapter 7 bankruptcy every 8 years. If you filed a Chapter 7, you got a discharge in the prior 8 years, you're not eligible to refile. So it's 8 years from the prior filing date. You have to wait another 8 years until you can file another Chapter 7. If you have a Chapter 13 that you filed in the last 6 years, you're also not going to be eligible, with a few exceptions to that. So if you filed a Chapter 13, got that discharge, you have to wait 6 years from the point that you first filed the Chapter 13 to then move forward with a new Chapter 7 bankruptcy. There's also income limitations to Chapter 7 eligibility. If your income is above a certain threshold, we call it the median family income. There's this thing called the means test that the government's going to apply to your case. If your income is above a certain threshold, it's going to make it very difficult to get through a Chapter 7 and get a discharge, because the government, through the United States Trustee's Office, might object to your discharge as being an abuse of the bankruptcy system. So you can't file a Chapter 7 in the last 8 years, you can't have a Chapter 13 in the last 6 years, and then your income needs to be below a certain threshold. If it's above that threshold, we still might be able to get you through a Chapter 7. Things get a lot more complicated, and then if you're well above certain limits, it's just not going to be an option for you. You're going to have to explore Chapter 13 at that point. And then the other thing is assets. You're only allowed to have a certain number of assets in a Chapter 7. Now, that doesn't make you ineligible to file, it just creates some other complications that we're also going to talk about. So let's talk about the assets. Look, everybody has something. You know, people have always told me, I don't have anything. Look, you have clothing on your back. You got some basic household goods. You know, you got stuff. We've all got the junk of life, basically. Every one of us. There's no one that doesn't own any single assets. But for most of us, our assets are fairly modest, right? So a lot of times there's a real misunderstanding about how bankruptcy works. They think that, you know, you're going to get stripped naked and they're going to take all your stuff and throw you out of court and wish you good luck. It just doesn't work that way. Most of your assets are protected because there's laws that are called exemption laws. Look, exemptions are your friends. Exemptions are simply the things that you're allowed to keep to move forward with your life. The policy behind our bankruptcy laws is to give people what we call a fresh start, right? Bad things happen to good people, sometimes you have to move on. The exemptions further that policy and they let you keep a certain number of assets to move forward with. For most of us, the primary asset that we may have is going to be a home. You're allowed to have $75,000 equity in your home if you're under 60, not disabled. If you're over 60 or disabled, you're allowed to have $105,000 equity. Look, that's equity. That's not the value of your home, right? You take the value, you subtract the lien, the mortgage or mortgages that you have, subtract cost of sale, and that's how we figure out what your equity is. Now, in Colorado, this number's been climbing rapidly, which is a good thing, but it's creating a problem for a lot of people, and I always say, look, this is a good problem to have. But the homestead exemption protects your home up to certain levels. You want to keep your house? Great. Make your payments to your mortgage. If your numbers are below this, you're going to be able to do that. If they're above it, then we have to have some other conversations. For the car, the equity, and again it's equity, not value. Equity is value of the vehicle less the mortgage, the lien, whatever, the secured interest. $7,500 or $12,500. Tools are exempt up to $30,000, in retirement accounts that you have, IRAs, 401ks, all those things are going to be protected. If you have some assets above $1 million, that's a conversation that we need to have. I doubt you're contacting me to go bankrupt if you have over $1 million in your IRA account. So assets, for the most part, are protected. For most people that file a Chapter 7 bankruptcy, they're what we call a no-asset case. That means all the assets that the person does have are of inconsequential value. There's really nothing to take and liquidate for the benefit of your creditors, or they're protected under our exemption laws, which is a good thing. So if most of the assets that we have are protected, our basic household goods, our stuff, in the exemptions that I just explained, some of us might have some assets that are considered non-exempt, all right? Not protected under the law, not necessary for someone to move forward with a fresh start, not necessary to the health and wellness of their family, etc. So if you have non-exempt assets, that does not mean you cannot file a Chapter 7 bankruptcy. That just means that you have to risk losing that asset. And sometimes it makes sense. I mean, look, if you got to get rid of the airplane, the wave runner, the ATV, the camper, the trailer, the yachts, the boats, if you have to get rid of these things, if that's the price you have to pay to wipe out your debt and move on with your life, sometimes that just makes sense. Now, if you have non-exempt assets, there are other options available to you. Sometimes you can buy it back from the bankruptcy trustee. Let's say you have, a jet ski that, the family just loves or whatever, and it's worth a couple $1,000 and it's super important to you. You don't have to lose it. You can simply buy that asset back from the bankruptcy trustee. They'd love to sell it to you. It's easier for them to collect the money that way. And you get to keep the asset. You just have to buy it back from the bankruptcy estate. Other options, if you end up having a lot of non-exempt assets, and we're seeing this a lot with homestead equity above the allowed amounts, Chapter 13 becomes an option to explore at that point. So there's always options with non-exempt assets, and I kind of explained real quick what those are. No protection for the guns, the Bronco season tickets, the boats, the campers, the trailers, these sort of things. Unfortunately, that's the price you got to pay sometimes when you're looking to wipe out your debt through bankruptcy. But a good bankruptcy lawyer can help you do some pre-bankruptcy planning with some of these assets, and I'd be happy to explain how that works. Let's talk a little bit about debt, all right? Obviously, you're having some debt issues if you're exploring bankruptcy options. The debts that you have can, on a very simple level, be broken down into two different categories. You have debt that are dischargeable, and then you have debts that are non-dischargeable. Assume a debt can be wiped out in a bankruptcy. That's the starting point. Credit card, retail card, medical bill, repos, foreclosures, collections, on and on and on. Make the assumption that a debt can be wiped out unless it's non-dischargeable. Non-dischargeable debts, taxes, child support, student loans, debts incurred via fraud, and that's a complicated situation that you're going to need to talk to someone about if you might have some fraud going on. Those are the main debts that you're not eligible to wipe out in bankruptcy. Some of the taxes you can actually get out of, but taxes get very, very complicated. If you have tax issues, you got to get a high-level bankruptcy attorney to make sure you get those resolved properly. Make the assumption that you're not going to get out of them. The student loans, look, they're never going to go away, unfortunately. Some people are finding avenues outside of bankruptcy where you can get rid of them. If you're disabled, you might be able to get rid of them through bankruptcy. That's a painful process. There's better ways to crack that nut. And then the alimony, the child support is absolutely never going away. And if you're not current on those obligations, that is an extra complication to your bankruptcy. So break a debt down into what's dischargeable and what's not dischargeable. The other categories you want to break down into what are secured debts and unsecured debts. Most debts, the credit cards, the medical bills, these are unsecured. A secured debt is your home mortgage, your car loan. Those are the typical types of security interests. Secured debts are a little bit complicated in bankruptcy, so you actually wipe out the underlying debt. When I bought my house, I signed a promissory note, which was a promise to pay X amount of dollars to the bank. Now, to secure that note, they put a lien against my house. The bankruptcy actually wipes out the note. So technically speaking, if I go bankrupt, get a discharge in Chapter 7, I no longer owe on that note. However, the bank lien survives the bankruptcy. So if I want to keep my house, I got to keep paying. There is no such thing as a free house or a free car in bankruptcy, despite what many clients have tried to tell me over the years. You want to keep your house, you want to keep your car, you better keep making those payments, even though you've technically wiped out the debt through the bankruptcy. Now, bankruptcy is a great way to get out of those assets if you're upside down or no longer want them, and that happens a lot with vehicles. Let's talk a little bit about some nuts and bolts about the process of how you actually get a case filed with the bankruptcy court. First and foremost, everyone that files bankruptcy now, whether it's Chapter 7 or Chapter 13, has to go through what they call a counseling class. It's a pre-filing requirement. You do it on the internet. It costs 20 to 30 bucks. It's not a huge deal, but you're not eligible to file for a bankruptcy unless you have that counseling certificate done. We send you the info on where to go to do that. It's not a huge impediment, but it's something that has to be done, and the certificate's only good for 180 days. So you have to have your case filed within 6 months of doing that counseling class. That's the first thing you have to do to really get the process going. There's a lot of paperwork that your attorney's gonna need, okay? This is complicated stuff. Taxes, pay stubs, bills. Every good lawyer should have a packet that they're going to need you to complete and get them a lot of these documents, okay? There's a lot of prep work. Most of the work from the attorney's perspective is done prior to the case being filed. Filing fee for Chapter 7 is $335. That money goes to the bankruptcy court. You pay your lawyer pays that when they file the case for you. We require that all our clients pull their credit reports. We do that for them. We pull all three. It's $35 or $55 to do that. It's important that you get all your debts listed in your bankruptcy. It's extremely important that you get all your debts listed in your bankruptcy, and so that's why we require that you do that. So, find a good lawyer, find someone that you're comfortable with, find someone that you can trust. They have a process outlined that you're going to want to follow. You're going to have to get all this paperwork together. You're going to have to figure out a fee with the lawyer. You're going to have to pay them money for filing fees for credit reports, and so the attorney can get paid as well. Typical office for us, usually from the point we get everything we need, we have you filed in about a week. After we get everything together, we review the paperwork. Myself and my paralegal calls you with questions. We go over the paperwork, make sure we agree with everything. You're signing off on the authenticity and accuracy of all that information, as am I. So we go over that paperwork together, we sign it, and then we file the case electronically through the court. It's all done through the computer. Once your bankruptcy is filed, something called an automatic stay takes effect, and that's a big deal because the automatic stay protects you. Lawsuits, harassments, garnishments, collections, foreclosure, everything stops once the case is filed. So getting filed is a big, big deal, and you really want to make sure that you get filed as soon as possible if you have some of these creditors breathing down your neck. So you're filed, you got the ball rolling. A month after you file, approximately, you have what's called a 341 meeting of creditors. It's a meeting downtown. It's an opportunity for your creditors to show up and question you if they want to. They rarely show up. Your lawyer will be there. I will always be there. Your lawyer should be there with you. If you have a good attorney, your lawyer will represent you at the 341 meeting of creditors. You do meet your Chapter 7 panel trustee. This person is not a judge. There is a judge assigned to your case. Most likely, you're never going to meet your federal bankruptcy judge, but you will meet your Chapter 7 panel trustee. Look, this individual, this is a lawyer. They're good people for the most part. They're doing their job. Their job really is to interview you, to verify the authenticity of the paperwork you submitted, to check a bunch of boxes. But what they're really doing is they're looking for assets that can be liquidated to the benefit of your creditors. They have an obligation to find assets if they exist, to liquidate them and make a payout to your creditors. And that's how your creditors get a partial payment if you are an asset case. Again, remember, most Chapter 7 cases are no asset cases. That process is pretty simple. On average, it's 5 to 10 minutes where you're actually in front of the trustee being questioned. Again, you've met your lawyer beforehand. You do the thing. I always meet with my clients before and after the meeting to make sure all questions get answered. Everyone understands where we are in the process. After the creditor meeting, There's 60 days, okay? There's a 60-day window where we're basically waiting to see if anyone's going to object to the dischargeability of the debt. If there was some fraud, the creditors could do that. If the government was going to object to you getting the discharge in Chapter 7, they would do that during that same time frame. Now, there's a lot of other work going on behind the scenes in this, but that's why you pay the lawyer to do all this for you. You file, you go to the meeting, you wait 60 days. During that 60 days, you need to do a second counseling class. They call it the financial management course. Again, you can go to the same place on the internet. You went to get the first class, you get the second class, you make sure you get that to the lawyer so he or she can file that with the court. That's required before you're eligible for the bankruptcy. Assuming everything goes smooth and you've listened to your attorney and done all the things that have been required of you and called or contacted your lawyer with questions, always get your questions answered, don't make any assumptions. 4-5 months after the case has been filed, the piece of paper shows up, it says discharge of debtor, that's you. The debt that is eligible to be wiped out is now wiped out. If you're a no asset case, your case will close pretty quickly. If there are some assets to be liquidated, your case will be open for longer while the trustee administers your estate, but it doesn't slow down your discharge. You have the piece of paper that wiped your debt out, and you get to move forward with your life. In a nutshell, that's the process of a Chapter 7 bankruptcy. All right, great news. You got your discharge, you get to move on with your life. There's still a few things you need to know. If you come into certain assets, inheritance, life insurance, certain property settlements, if you come into these assets 180 days after your bankruptcy case was filed, legally the trustee has a right to pull those assets back into the bankruptcy estate. It's very unusual, but it does happen from time to time. So there's this 6-month window basically from the point that you file that certain things can be pulled back in, and normally that's some sort of inheritance. After that 180 days, you move on with your life. You get a new job, you win the lottery, go make $1 million is what I always tell people. Move forward, you are free at that point. After bankruptcy, look, your credit actually begins to repair itself very, very, very quickly. You will find usually a year out, your credit score is higher then than it was right before you filed bankruptcy. Reason being, you've now wiped out all these debts. I recommend and remind all my clients 6 months after their case is done to pull your credit report. You're going to want to pull your credit report and take a look at it. Not all the debts on there will be zeroed out. It should say discharged in bankruptcy. Unfortunately, the credit report, the agencies are quick to put debt on and slow to take it off. So you're going to want to follow up 6 months or so after the case is done and make sure that the debts that were discharged in the bankruptcy say so on your credit report, because that helps your credit score improve as well. Now remember, you might not have wiped everything out. There's taxes potentially that you're going to have to deal with. Obviously the child support, the alimony, you better have remained current with those payments. And then the student loans are waiting for you on the other side as well. Now while you're in the bankruptcy, the automatic stay takes effect. So these folks have left you alone during that time frame. But 6 months or so after your case is filed, assuming the case closes then, it's time to contact your student loan lenders. It's time to contact the IRS and the Department of Revenue and get on a plan to resolve those obligations that survived the bankruptcy, if any of them did. Be very, very, very careful with your credit after the bankruptcy's done. Take this opportunity, take this fresh start and maximize it. Don't make some of the same mistakes from the past, right? Try to learn from the things that have happened. Be very, very wise with your credit. Look, you're going to get swamped with car loan offers, with credit card offers. They love you coming out of bankruptcy. They know you just wiped out all your debt, and they want to get you back stuck in that debt trap again. That's corporate America. That's the way it is. It's going to happen. Be careful. Be mindful of it. And try to stay away from the credit cards, and definitely stay away from car loans at 21%, because if you do that stuff shortly after your bankruptcy, unfortunately, you're setting yourself on the path to call me again in a couple years, and you absolutely do not want to do that. Okay, if you made it this far, I applaud you for taking some steps to educate yourself and find out what your options are. There is a lot more to it than what I've shown in this very brief video. I couldn't possibly cover all aspects of it. I absolutely do cover all aspects for my own clients. So look, thank you. I really wish you the best of luck. This is a huge decision. the way I encourage most of my clients to look at it is I say, this is a business decision, and that's the way you want to view it. Whether or not you should move forward with a bankruptcy. First of all, talk to a good bankruptcy lawyer. Hello, find out what your options are. But as you think about whether or not it makes sense for you, you got to ask yourself some hard questions and try to remove the emotion as much as you can. It's not possible to remove all the emotion because it's such an emotional and difficult spot to be in. And boy, I have sympathy for you. But if you can kind of take a step back and read the forest, so to speak, make a good business decision. Make the right decision for you and your family. Because I promise you that the creditors on the other side of this debt, the big banks, the corporate entities, they just don't care. They really don't. And if you think they're going to be mad at you, you're wrong. Because as soon as you get out of this thing, the same people are going to be sending you cards again to get you to rack that debt up again and try to trap you in that debt trap again. Look, I wish you the best of luck. Thanks so much for spending a few minutes with me here. And I hope this helps you make an informed decision. Don't hesitate to call, email, text. There is no charge to speak with me on the phone for, in 15 to 20 minutes usually I can answer your questions, tell you what I think your options are, and try to get you on a path to moving forward with your life. Thanks so much, and I wish you the best of luck.